You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News Bankruptcy columnist Bill Rochelle. Be sure to check out his daily bankruptcy column, available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Two pretty interesting items today. First one, we have news on Dewey LeBoeuf. The law firm, prior to filing bankruptcy, for the last 6 weeks of its existence, burned through $43 million in cash. That sounds like a lot of money. Is that out of the ordinary? What to make of that metric?
Well, when I read it, I first thought it was a typo, but then I checked and I said, no, this is a very responsible law firm. These are the lawyers for the bank, J.P. Morgan. They wrote it.
$7 million a week.
Well, you betcha. This was the last 6 weeks before Dewey LeBoeuf went into the bankruptcy tank. The firm had pretty much folded already. Bunches of partners had already left by the dozens, probably at least 100 by that time. So there wasn't terribly much money coming in. Anyway, that first quarter of the year is one of the worst cash flow quarters for pretty much any law firm. So I suppose in retrospect, that kind of a cash burn isn't terribly, surprising for a firm that is going out of business and everybody's deserting the sinking ship. It is, however, one very large ouch factor for the secured lender, J.P. Morgan. They really didn't have a whole lot of choice, because if they simply just threw everybody out, stopped the operations, there would be no way on God's earth they could collect what was about $250 million of outstanding accounts receivable. So the poor old bank had not much option but to keep ponying up money to keep the operation going, to collect receivables.
That's really interesting. I mean, what does that say about banks making loans to law firms? Is this something that's going to change the business proposition for them?
I suspect it will, at least for a period of time. I mean, what we're hearing is that banks have begun to examine their portfolio of loans to law firms. I suspect the Dewey experience will make it more difficult for law firms to get credit in the near future. But, you know, Lee, frankly, the way it is out there, you go a year or two from now when people have forgotten about Dewey LeBoeuf, and there will be money looking for a home. Banks are going to make loans again. Devil take the hindmost. They will have forgotten that Dewey ever existed.
It's really interesting, though, because we're talking about, at least in the short term, law firms, large law firms, after the top five, so to speak, are in a structural recession. Are they going to be facing a financing crunch to kind of compound the issues that they're facing on the other sides of their business?
Wouldn't surprise me. It really depends upon the way their bank lenders are going to behave. Most of these are not very long-term loans. I mean, they're not 30-year loans, for instance. So therefore, when these loans to banks mature, the question is going to be, will the lenders allow them to roll them over, or are they going to squeeze the law firms? If they squeeze the law firms, of course, then you got to know the Dewey situation, and it will then become a self-fulfilling prophecy. They can't pay off the loan, the law firm will go kaput, and then the loan will be even worse off. So really, in some ways, once banks make these loans, it's going to be hard to get out from underneath.
Yeah, tough time to be running a law firm for sure. We also have news on the Houghton Mifflin case. The educational publisher is facing an effort by the United States trustee to knock them out of the Southern District of New York. The company used a tiny subsidiary to establish venue. Are they going to get kicked out? What's going to happen here?
I don't think so. I think it's going to be a cold day and you know what before a bankruptcy judge in New York or Delaware throws a large case out and sends it back to the hometown. This case, the Houghton Mifflin case, is really a classic example of the gigantic loophole that Congress has in the venue regulations for where you can file a bankruptcy. In this particular instance, Houghton Mifflin, which has about, I'd say, $1.3 billion a year in revenue, is basing its right to reorganize in New York on the revenue of one little tiny subsidiary that has annual income of about $200,000 by my rough calculation. That is about 1/100th of 1% of the entire enterprise's income. And because this one little subsidiary has its principal asset, namely a lease in Manhattan, the entire family of companies is basing its right to reorganize in New York on the existence of this one affiliate. And believe me, Lee, odd as it may sound, there is nothing untoward about it. This is exactly what the statute says.
This reminds me of the Winn-Dixie case, where the company set up a store just a couple of weeks before it filed bankruptcy. They're only tied to the jurisdiction, and then they got kicked out. But I imagine that the claims being made in this case are a little bit less, a little bit more tenuous.
I think that's probably right. Of course, it all goes back to, of all things, Eastern Airlines. If you try to find a bankruptcy case called Eastern Airlines, you ain't never going to find it. That's because the Eastern Airlines case was conducted under the name of Ionosphere Clubs, which was their first-class club. It happened to have its main office in New York. So that's where Eastern Airlines filed Chapter 11, because Eastern was based in Miami. And this is how it all began.
All right, Bill. Interesting stuff. Venue is always a hot topic in the bankruptcy space. Thanks for stopping by. That's Bloomberg News Bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to check out Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube and follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.